All rise. The Court of Appeal in the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, good morning, everybody. Welcome to a session here in Seminole County. We try to travel through our district each year, so we're very grateful to Chief Judge Chase and everybody here in Seminole County for inviting us here. And we're happy to have the turnout. I'm sure it's not everybody who's participating in the cases, so thank you for being here. I'm Judge Edwards, presiding. To my right is Judge Makar. And to my left is Judge Eisnagel. Do we have any law students here? I was told that they were invited way in the back row. Okay, a couple in the back row. Which school?
Seminole State College, Your Honor. It's Brooke Fairview Study.
Great, excellent. Well, thank you for being here. All right, before we start, if anybody has any noise-making devices, phones, computers, whatever else, please put them on mute. Or feel free to turn them off. And with regard to counsel, we have our little color-coded blocks on the table, I think. If not on the table, certainly on the podium. The 20 minutes is your entire time for the appellant. You get to tell us how much time you'd like for rebuttal. When it's green, you're in your main time. When it's yellow, you're going into your rebuttal time. When it's red, it's time to stop. If I see you as the appellant going into what looks like your rebuttal time and somebody takes a breath long enough, I'll try to point it out to you, but it's your time. You can use it as you wish. So are you all able to hear me? I'm not sure we have really much, but you're able to hear okay? All right, great. All right, with that, we'll call our first case, which is 25-708, Hernando County versus McGee and Mason and Joseph Mason, Esquire.
Good morning, Your Honors.
Good morning.
I'm Melvin Talria, representing the appellant Hernando County, and I would like to reserve 5 minutes for rebuttal.
5 minutes, okay.
May it please the court. The trial court committed reversible error by not granting the county's motion to dismiss in this case. The motion was based on two matters. The first was that the county was sovereignly immune from suit based on the unexecuted retainer agreements, and therefore the trial court lacked subject matter jurisdiction to hear the complaint. The second base was that because the retainer agreements were not express written agreements, they were unenforceable, and therefore the complaint failed to state a cause of action. After hearing the motion to dismiss, the trial court found first that sovereign immunity was no longer related to subject matter jurisdiction, and therefore the trial court couldn't consider the charter because it was outside the four corners of the complaint. Because it couldn't consider the charter, it couldn't compare the complaint against the charter, and it determined, therefore, that the unexecuted retainer agreements could potentially be an express contract. And it ultimately decided, therefore, that the county was not sovereignly immune from suit based on the unexecuted retainer agreements.
Counsel, let me ask you a question, please.
Yes.
How does this case differ from the Sarasota County Public Hospital District versus the Venice HMA case? The second DCA.
I'm sorry, I'm not familiar with that case. I apologize. Can you, I will tell you.
Well, I'll tell you, in that case, there was a general statute and special statute and local ordinances saying the county would reimburse hospitals who provided for indigent patients, and they were not reimbursing some of the private ones according to the case. There was not an express written contract, but Judge Lucas out of the second held that taking everything together, there was still an express contract.
Thank you, Your Honor. Thank you. Now I do recollect that case. The name didn't ring a bell. So in that case, there was an ordinance entered by the municipality that actually provided for the payment of those hospital bills. In this case, there is no such ordinance. Even though it was required in the charter that there be an ordinance that authorized the agreement or the execution of these agreements, no such ordinance existed.
But even if there had been an ordinance, would that constitute an express written contract?
In this case, if there had been an ordinance that specifically said that the city commission authorized authorized or agreed upon these retainer agreements, then yes.
Go ahead, thank you.
Thank you. So the trial court's order was erroneous for 3 reasons. First, sovereign immunity is in fact related to subject matter jurisdiction. 2, the city's charter was governing law, not an extraneous document, and so therefore the 4 corners rule didn't apply. And 3, the charter was in fact incorporated into the complaint, and so the trial court should have considered the charter and compared the complaint and the attachments to the charter.
Let me ask you about the subject matter jurisdiction first. Subject matter jurisdiction is the power of the court to adjudicate that kind of matter, correct?
Yes, sir.
Well, if the court couldn't adjudicate whether sovereign immunity applied or not, I mean, it's got to have subject matter jurisdiction to answer that first question, doesn't it?
Yes, sir. It does have subject matter jurisdiction to answer that question.
And if it gets it wrong, then you say they lose it? I mean,
If sovereign immunity applies, the court has no subject matter jurisdiction to hear the complaint. It has no subject matter jurisdiction over the complaint.
go ahead.
Thank you, Your Honor. Sovereign immunity, as I said, is related to subject matter jurisdiction. In Wallace versus Dean, the Florida Supreme Court said, quote, sovereign immunity may shield the government from action in its courts, i.e. a lack of subject matter jurisdiction, end quote. The court explicitly stated that sovereign immunity relates to subject matter jurisdiction. The trial court didn't rely on the Supreme Court's holding in that case. Instead, it relied on the first DCA's ruling in a case called Citizens Property Insurance versus San Perdido Association, when it determined that sovereign immunity was no longer related to subject matter jurisdiction. But for some reason, the trial court neglected to read the Supreme Court's later ruling on that same case. The Supreme Court said that because the legislature had partially waived sovereign immunity as to certain types of claims against citizens, therefore trial courts could hear those claims. They had subject matter jurisdiction. But in this case, there has been no parallel legislative waiver of sovereign immunity with regard to contracts such as the unexecuted retainer agreements. And this court's ruling in Brevard County versus Moorhead, this court followed basically the Supreme Court's San Perdido ruling. In Moorhead, which was a quasi-contractual case, this court held that because no written contract existed between the parties, the county did not waive its sovereign immunity, and the trial court therefore lacks subject matter jurisdiction over the quasi-contractual claims in the complaint. This court has not retreated from the Moorhead case, so it remains controlling law.
Counsel, what's the practical impact? If you have sovereign immunity, then you win, right?
If you have sovereign immunity, you're basically protected from claims.
Right?
Yeah. Mm-hmm.
And you prevail.
Yes.
Okay. Does it matter in this case whether sovereign immunity is a subject matter jurisdiction issue or not?
It does.
Okay. Why?
I'll explain why. Thank you for the question. It matters because the trial court found that it couldn't consider anything outside the 4 corners of the complaint. But when a motion to dismiss raises the issue of sovereign immunity, one of those exceptions is that you can consider extraneous documents or matters gathered outside of the complaint. And so if the court had found that sovereign or that subject matter jurisdiction applied to sovereign immunity, it could have, and it would have, hopefully, considered the charter. Now, of course, the trial court considered the charter an extraneous document, which it was not. It was governing law. But that's why sovereign, and that's why the issue of subject matter jurisdiction matters here. Shall I-
Counsel, it seems to me the FLE's biggest point is that the initial retainer agreement and I think it's called the restated retainer agreement, plus city council minutes, notes here and there and yonder, legislative notes, you take them all together and you get an express contract. I mean, that seems to be their position, I mean, among others, but that seems to be perhaps one of their stronger points. What do you say about that?
Thank you for the question. I say to that the, first of all, taking those or cobbling together those documents does not amount to an express written contract because the contracts were not executed in accordance with the charter, which is the governing law, or was the governing law for the now dissolved city. Also, the minutes that they attached.
Well, wouldn't the charter have more to do with whether there's authority for the express written contract?
It does have to do with that as well, yes. And it does say that the charter says that the city commission has the authority to administer the government and also to hire and to decide upon the compensation for the city attorney. So these kind of combining your two questions there, there is no indicia in any of the attachments that the city commission approved the hiring of McGee and Mason and Mr. Mason, or that it set the compensation. The minutes that were attached were from 2019, which was 9 years after the alleged restated retainer agreement and 19 years after the initial retainer agreement. So, and not only that, but those minutes from 2019 say nothing about the retainer agreements. What they talk about is some invoices that had been provided by the athletes to the city commission for payment. But even then, the invoices they're nondescript in the minutes. So we don't really know what invoices they're talking about. So it's really just conjecture to say, or to think, well, we've got these minutes over here 9 years later, they must apply to the retainer agreements. Does that answer your question?
Yes.
Okay, thank you. Thank you so much. Okay.
Well, Counsel, if I could ask a question.
Yes, sir.
You're not out of the meeting yet because it's a motion to dismiss, right?
I'm sorry, can you repeat that?
There's a motion to dismiss,
Yes.
right? And you can bring this issue up again, can't you, with a motion for summary judgment?
Yes, sir, and thank you for asking me that question.
So it seems like what we're here looking at today is simply the motion to dismiss, whether there has been enough in the complaint and any other items attached to it that might be of relevance to at least state a claim for breach of contract, correct?
Yes, one of the claims is for breach of contract.
And the case law is pretty clear. You don't have to have a 15-page written signed agreement to satisfy the standard of waiving sovereign immunity. You can have 3 or 4 different documents that you put together demonstrate an express agreement, correct?
I agree that probably is correct, Your Honor. So I'll
And
try
are you trying to assert the immunity of Wikiwachi or the county's immunity?
Great question. I'm asserting that the city had sovereign immunity because because the retainer agreements were not executed in accordance with the charter, and by extension, the county, as the successor in interest for the city, has sovereign immunity with regard to those same unexecuted retainer agreements.
And what's the mechanism when a city is dissolved, as Wikiwachi was? What's the mechanism for the county to take over the assets and liabilities of the enterprise?
That was a special law enacted by the legislature in 2020 that basically said, the city of Wikiwachi is dissolved and all assets and legitimate liabilities of the city are transferred to the county.
It did say legitimate?
It does say, it says the word legitimate. Yes. And I want to go back to your other question, too. I think you were trying to ask me why bring it up now and not argue it as an affirmative defense later on? I think that's what you're trying to ask me, but maybe I misinterpreted.
That wasn't what I'm asking, but you can answer that question.
Okay, well, I guess I stepped into that one.
Yes, why
Okay.
not bring it up in summary judgment?
Yes, okay, so the reason for that is, according to Florida Highway Patrol versus Jackson, that was the Florida Supreme Court in 2020. They said an erroneous denial of sovereign immunity causes injury that cannot be remedied on appeal. And then it went on to say that precisely because sovereign immunity includes immunity from suit, entitlement to sovereign immunity should be established as early in the litigation as possible. That is especially true in light of the separation of powers principles that animate the doctrine of sovereign immunity. And so, Your Honors, when, if we were to say, well, you could argue this later on, the county, basically, the taxpayers have to pay for this. And so the idea is that the taxpayer should not have to pay for ongoing litigation that could have been solved from the outset.
No,
Or they
but
could have been
the
resolved from the
Supreme
outset.
Court quote you just read said as early as possible,
Yes, sir.
which seems to me to open up, you can involve a motion to dismiss stage, fine. If you can't, maybe the next best is summary judgment. Once you have more factual development of the case.
Mhm. Well, I mean, knowing how long sometimes court procedures take, it could be
I mean,
months.
I don't think we're not unsympathetic to delays that might arise from litigation.
Understood. I think that as soon as possible would be at the motion to dismiss stage. And because the issue of sovereign immunity was raised in the complaint, the county was entitled to bring it up now at the motion to dismiss stage.
Was there any evidence to support a pattern of paying lawyers for services over time for the city?
There were invoices attached to the complaint, but it's not clear from my perspective it's not clear from my perspective that those invoices were actually paid. There's no indicia that they were. I see my time's not up there. There's no indicia that it's a result of the retainer agreements at all.
All right, you can reserve your rest of your time, okay?
Thank you, Your Honors.
Good morning.
Good morning.
May it please the court. My name is Bruce Snow. I'm an attorney in Brooksville, Florida. I represent the Applees, Joseph M. Mason, and McGinn Mason, PA. This case really has its beginning in 2002 when the city of Brooksville approved a retainer agreement engaging both Mr. Mason individually and his law firm as the city attorney. And as
Brooksville or Wiki Watson?
I'm sorry, Your Honor.
Brooksville or Wiki Watson?
Excuse me, if I said Brooksville, I was mistaken. It was the city of Waukewashi that engaged Mr. Mason and his law firm.
Counsel, why is the charter not just the law?
Your Honor, I would refer the court to provisions of the Florida Evidence Code. Part of my responsibility, I think, as the appellee is to defend the trial court's order. It provides that ordinances and the city charter originally started out as a special act of the legislature, but by general law, all special acts became an ordinance. I could find the statutory site, which I think I did in my brief. And the rules of evidence says that an ordinance, the court may take judicial notice. If a request for judicial notice has been made, there's no indication in the record that a request for judicial notice was requested. Now, Your Honor, I think ultimately the question of the charter is going to be an appropriate determination by the court. We're certainly willing to discuss the provisions of the charter as we did at the trial level. Counsel indicated in argument that the execution of the retainer agreements were not executed pursuant to the provisions of the charter. Respectfully, there are no provisions of the charter that says it has to be executed in the fashion the county has asserted in their brief, that it has to be notarized, and the pages have to be numbered, and things of that nature. They do argue in the brief that there's some mode in the charter that says that certain contracts had to be approved by an ordinance. However, that's section 2 of the charter that we pointed out is inapplicable to this case for 3 reasons. 2 of the main reasons are that provision in the charter said that a contract that was going to be more than a fiscal year had to be approved by ordinance. Well, the retainer agreements in the first instance do not have an established term. They have an undeterminable term. And under the law, they are therefore contracts at will, meaning they can be terminated by the city in a month or 6 months or at any time. Therefore, they were not contracts that exceeded the fiscal year. Also, contracts between attorneys and their clients by public policy are terminable at will. And this is a contract between an attorney and a client, and under Florida law, that contract is terminable at will, and therefore is not a contract that exceeds the budget year of the city. Therefore, the section 32 cited by the county is not applicable and is not a requirement as to a mode of this contract.
Counsel, do you agree that it has to have an express written contract for there to be an implied waiver of sovereign immunity?
We do, Your Honor.
All right, then let me ask you about this. The initial retainer agreement, in terms of documents that you attach to the complaint,
Yes,
that's executed only by your client, the copy you attached, correct?
that's correct, Your Honor.
Okay, and then Exhibit B, which is the restated retainer agreement, your client was the one who set forth how his client could accept the contract. In other words, in the retainer agreement itself, it spells out what the city was supposed to do. It was supposed to initial each page, and there's little boxes for that. It was supposed to be signed by both the mayor and attested by the city clerk. It was supposed to have the city seal, and the signatures of the mayor and the city clerk were supposed to be notarized according to what your client put in the retainer agreement, correct?
It does have those provisions as instructions that were given.
So in other words, your client says, if you want to accept this contract as an express written contract, city clerk signed it, mayor signed it, initial all the pages, and have your signatures notarized.
The appellees do not view those as conditions of the contract. They do not
That was what your client, Mr. Mason, told the city. This is how you accept the contract, correct?
He obviously indicated that suggested these things be done.
Not suggested. He said he told them to do it. He didn't suggest that they do it. He told them this is what you need to do, correct?
And that is correct.
All right. And what we have in the restated retainer agreement, it ratifies or restates that the first retainer was entered into, correct?
That's correct.
But the restated or the second retainer agreement is signed by your client and the mayor only, not by the city clerk. Right?
That's correct.
So are we into the meatloaf song of 2 out of 3 ain't bad, and that's good enough?
No, I don't think so. If we look at the restated retainer agreement, we look at the certificate of acknowledgement that is signed by the mayor. It specifically provides that the mayor is entering into a certificate acknowledging, as the mayor, that the mayor and city clerk respectively in our respective official capacities on behalf of the city do hereby certify that the city council of the city of Wicked-Washy in an open public meeting duly notice convened and by unanimous vote confirm its earlier approval of the July 30, 2002 retainer letter agreement and confirm the retention and acknowledged and agreed both to the above described scope in terms of the engagement by the city of Wicked-Washy of Joseph L. Mason and McGinn
But
Mason.
it's signed by the mayor only.
Signed by the mayor.
Not attested by the clerk.
That's correct.
So we certainly don't have a fully executed contract.
That may very well be the case. It's signed by the mayor, and
But your client has had it set up to be signed by the mayor and the city clerk,
and
notarized.
that again is the case. We would again point out that that a document is signed by the authority of the city may very well be an express written contract. And I would point the court to the Frankenmuth case, where the contract in that case was not even signed by an individual who had any authority, signed by a constitutional comptroller, and had not been approved by the county commission. And instead, the comptroller had signed that contract. The county commission didn't know about that. And the comptroller later was removed from office. The comptroller position was changed back to clerk of the court. Litigation occurred over the express written contract that the comptroller had entered into without the authority to have entered into it. And the Supreme Court in the Frankenmuth case said that the county commission had the ability to ratify that contract even though they did not know it had initially been executed, and even though the person that executed it did not have the authority to have executed it. And the Supreme Court then set forth a provision for a governing body to ratify a contract that had not been executed in a proper format previously. And the Supreme Court set forth a three-pronged test for ratification. Number one, the city or the governmental body has to have had authority to have entered into the contract. Number two, that when its contract is later ratified by that governmental body, that ratification must be done pursuant to any formalities that were subject to initial improvement. Again, the county has argued that the mode that required an ordinance to be adopted, we pointed out that section does not apply. The public records, or excuse me, the Sunshine Law had to be complied with. And those are factual issues, not legal issues at this point. But the second thing is that when the county ratified, or the government agency ratified, it had to be done in the same fashion it was approved to begin with. And then the third prong in Frankenmuth is that the government becomes aware of and it has knowledge of the terms of the agreement that had not been initially approved by them, but they ratified it nonetheless. And that litigation ended up in federal court, and the federal court, applying the principles the Supreme Court of Florida said in Frankenmuth, said that the county is bound by that contract because of their subsequent conduct by approving payments under that contract by approving budgets under that contract, by incorporating the technology of the computer system under that contract, by having knowledge of audits that address that contract. And ultimately in Frankenmuth, it was determined that that governmental body, the county in that instance, had ratified a contract that they didn't even know had been executed initially, that they did not, it was executed by somebody that did not have authority. So,
Counsel, can I ask you just a factual question? What amount of attorney's fees, the value of the attorney's fees is being sought in this case?
Your Honor, my recollection, approximately $1.3 million.
Was that all accrued through attorney time in one year?
No, Your Honor, that was, the attorney represented the city ultimately for approximately 20 years. Representing the city up until it dissolved.
Are there 20 years worth of invoices?
Your Honor, there are, and as we've set forth in our complaint, I think there had been 12 or 13 payments that the city had made pursuant to the retainer agreements, totaling about $277,000 approximately.
Is there no statute of limitations on contract, breach of contract?
As the statute of limitations begins to run once the contract has been terminated. So the contract was terminated at such time as the city was dissolved. The contract continued to run up until the city was dissolved in 2000.
Counsel, I'm not sure that this issue is really right yet, but doesn't the statute on a contract begin to run when it's breached?
When it's breached, that's correct.
Not when it's terminated. When it's breached.
When it's breached, it was not breached, Your Honor, until, because payments had been made within the last couple of years before the city was dissolved. So it had not been breached as of that time.
There were a lot of time there where there was no payment at all.
That may be the case, but.
Well, I think it is the case.
And then there are subsequent payments, though, that then would bring it within the statute of.
So the retainer agreements, it's obviously it's your position that that's the written express contract, correct?
That's correct. Number one.
Is it only the initial agreement and retainer, and then the what's it you guys call it, restated retainer? Does that make up the entirety of the express written contract?
Your Honor, it's our view that those retainer agreements do make up the express written contract. Under the Pan Am tobacco case, but by the same token, alternatively, under the Frankenmuth case, those contracts also give rise to the basis for the city to have ratified the initial contracts, which we allege happened.
Taking the ratification out for just a moment.
Yes.
I'm just trying to wrap my head around all of the years before the ratification where work was being done, but I'm not sure if any payments were being made during those years. If there were, they were very small. Right? Do you agree with that?
Compared to the work being done, the payments were very small. I would agree with that.
So before the ratification, for that period of time, how do we know? So if the city was made some payments, right? How do we know that those payments were made pursuant to the written contract when it wasn't accepted? How do we know it wasn't just sort of you bill an hour and we'll pay you sort of unwritten agreements, right? How do we know they were operating under the written agreement as opposed to just something else?
Well, obviously, Your Honor, that's going to be a factual issue. And we would anticipate that factual issue, if that's raised as a kind of a factual defense, that the evidence will show that the city commission was aware of the agreement, that the city commission had approved payments. It will also show we would proffer at such time as the facts are developed that the city of Wickawassee did not have sufficient funds always to pay its attorney, even though it was engaged in very significant.
But that doesn't necessarily mean that they were operating under the written agreement, right? It's possible that you send the written agreement to the city and the city says, we don't like that, but we're okay with this firm, sending us invoices and just sort of.
Certainly, that's within the realm of possibility.
Well, isn't it your duty to show a written express contract, and that includes the formation, right?
And that's why we've attached it to our complaint. That's why we've made the allegations in the complaint that the services were rendered pursuant to the retainer agreements. And
So your point is that, hey, look, that fair question, but that would be more for summary judgment.
I think so, Your Honor, after the facts are established as to those matters. If somebody alleges that there's some other contract out there or some other arrangement, but we've alleged that the services were performed under the retainer agreements. At this stage of the litigation, the allegations within the complaint made by the plaintiff must be taken as true from a factual standpoint, and must be viewed as true as the court reviews this matter de novo as to issues of law.
Do you agree that the express written contract has to be enforceable in order to constitute an implied waiver of sovereign immunity?
Generally, yes. I would point out, and the trial court did not address our other counts that we raised, because we have also raised a constitutional claim, and as the court is aware, claims under the Constitution are not subject to sovereign immunity. Claims based upon a direct statutory authorization are not subject to sovereign immunity. Our counts 2 and 3 in our complaint raise a constitutional right, a constitutional cause of action, and a statutory cause of action based upon what we would argue is a direct authorization and mandate by the legislature under the general law that says the county shall assume the indebtedness. And that's in chapter 165.071.
But you would agree that they would only have to assume the legitimate obligations?
Your Honor, we would agree. First of all, legitimate obligations. Legitimate means legal. And just even though sovereign immunity, you can have a legal obligation that can't be enforced because of sovereign immunity, which is a privilege. It doesn't make it illegal. The provision in the special act that counsel referred to about that said we transferred, and that's done because the Constitution requires it, by the way, that we transfer the assets, legitimate liability assets, to the county. Well, chapter 165.022 preempts the provisions to the general law pertaining to how cities are dissolved. And as I pointed out, 165.071 says that upon dissolution, the county shall assume the indebtedness of the dissolved corporation. That is the applicable law, and that's to enforce the constitutional provision.
Counsel, thank you. Your time has expired unless any of my colleagues have anything further. Okay, thank you very much.
Thank you. Appreciate your hearings.
All right.
Okay, please support.
Hey, Counsel, before you keep your questions, but I have a quick question.
Yes.
Are you familiar with the Florida Supreme Court case Rojas versus University of Florida that came out in the last year or so that involved students at the University of Florida who sued to basically collect fees that they had paid for services that were not rendered during the COVID epidemic?
Yes, sir.
Doesn't that case sort of cut against your position here?
It does not, and.
I mean, there's a motion to dismiss, and the Florida Supreme Court allowed the case to go forward. And
Right.
there was no unified written contract. There were basically some websites that said, if you pay tuition, it's basically a contract. So, okay.
Yes, sir. That case involved the implied covenants of the contract. So there was an express written contract in that case. And I believe it was the financial agreement that said, okay, you pay this much for these particular, services.
But no one signed any documents in that case.
You're right, thank you. What they did was that the students actually applied for the financial assistance and they enrolled and attended the courses up to a certain point, of course, until COVID. And when COVID caused the shutdown of the colleges, as you know, the students sued because they said, well, we paid for these labs and in-person services, and those are implied covenants within the agreement. So this case, our case right here, there's no express written contract. And it's not, the appellants, the appellees are not saying that there are implied covenants within the express written agreement.
They are saying that the agreement, whether it was properly executed or not, that it was ratified by the city council.
Yes, sir, and
And again, this is at the pleading stage. All they gotta say is, here's the deal. You don't like the way the contract looked, the city ratified it anyway. I mean, they have to prove that later, but for right now, we have to take that as true, as did the trial court, correct?
well, first they have to, respectfully, I submit that they have to overcome the issue of sovereign immunity first. And the way they would do that is by showing that they had express and written contracts, which they have not done.
What about their ratification argument?
Well, two things.
I mean, first of all, there's a document that's expressed and written, correct?
Yes,
Okay. The only question is was it ever accepted, right?
correct.
Essentially.
Yes,
Other than I understand you have an argument about the signature, which I'm not sure if that's correct, but let's say, put the signature aside. We have a written express document that could be a contract if the city accepted it. You agree?
that could be a contract if the city
Okay,
accepted it.
why is ratification not enough?
Because there's no proof that the ratification was direct or was approved by the city. Because according to the document itself, the county commission directed the mayor and the clerk, city clerk, to sign as acknowledgments that the city commission did ratify it and directed them to sign it. And so the document itself fails to establish that the city commission even...
Who had authority to accept to ratify the agreement? The commission or the mayor and the clerk?
The commission.
Right. So why isn't the signature of the commission, or of the mayor and the clerk, why isn't that sort of ceremonial? I mean, if the commission approved it, why is that not enough? I mean, you're back to your argument that there has to be an actual signature.
Yes, if the commission approved it, it would be enough. But there's no indicia that the commission approved it.
Okay.
I mean, the document itself belies that fact. Because it says in there that but the certification of acknowledgement, by us signing here, we're certifying that the commission approved it.
But do they not allege that the commission approved it?
They do allege
Okay.
that the commission,
And we're at motion to dismiss, right?
we're at motion to dismiss. However, it doesn't say anywhere in the document when the city commission approved it. So that's questionable. The mayor's signature isn't even dated. So we don't know. There's so much missing information at this point.
I mean, isn't that, but at motion to dismiss, when they've made the allegation that the commission approved it. Look, I'm not saying there's not a lot of smoke here, that, I mean, there's certainly some cross-examination that could happen, right? Maybe summary judgment, but how aren't those points you're making now for potentially summary judgment or an evidentiary hearing as opposed to motion to dismiss?
Well, I'm making those points because respectfully, they established that the county has sovereign immunity because they're not express written documents.
The documents are express and written. That you have already agreed to that. I don't see how you can argue they're not. They're express and they're written. The question is, were they accepted by the city or ratified, right?
True, but according to the Ramsey case, which was cited in our initial brief, let's see if I can find it on here so I can give you exactly the wording. I apologize for that. Anyway, the court said in Ramsey that a contract that is not expressly, I'm sorry, a contract that is not executed in accordance with the governing law is not enforceable and it's illegal. So, and that's what gives the county sovereign immunity in this case, because it wasn't executed in accordance with the governing law. And that brings me to...
Counsel, unless my colleagues have other questions for you, you're a minute past your
Okay.
time, so
All right, thank you so much, Your Honor.
thank you very much. All right, y'all are excused, and we'll go to our second case.